All right, well, good morning. The title of our top session is The Impact of Darwinian Evolution Upon Judicial Philosophy and Interpretation. And as Dr. Dean was just describing, when we get into this whole subject of evolution versus creationism, we're not just dealing with a scientific issue, are we? It's not simply an issue that biologists and scientists talk about. It has worldview ramifications. And in fact, in the early 80s, I think it was, Dr. Henry Morris wrote a book, which is an outstanding book. If you have a chance to get this book and read it, please do so. This book that he wrote is called The Long War Against God. And in that particular book, he showed, I think very ably, how evolution is the philosophical foundation upon the major isms and anti-God systems of our day. Evolution is the foundation of humanism, the New Age movement, atheism, racism, Nazism, communism, and on we could go. And what I'm going to try to show you in this session is the tremendous impact that evolution has had on the American legal system. Specifically, how jurists or judges approach the United States Constitution. And here's a quote from a political science professor, Fred Cahill. And he says, "The appearance in the mid-19th century of the concept of evolution was an event of transcending importance to the development of American jurisprudence. This involved a shift from the rationalistic, deductive pattern characteristic of the pre-Darwinian period to the empirical, evolutionary approach that is followed today." And most of us look at our American legal system and we can tell something's wrong with it, can't we? How many think there's something wrong with our court system? Just one example. One day, the Ninth Circuit Court of Appeals, sometimes the Ninth Circuit is called the Ninth Circus because it's been overruled so many times. But one day, just a couple years ago, the Ninth Circuit Court of Appeals wakes up and decides that the Pledge of Allegiance in the classroom is unconstitutional. Or you may remember the story of Judge Roy Moore. He had the audacity to post a copy of the Ten Commandments in his courtroom, and that brought a federal lawsuit. And on we could go with these crazy decisions that seem out of whack. Most of us scratch our heads and wonder what in the world is going on. But the fact of the matter is, these things that we see all around us are simply the ripened fruit of a evolutionary worldview that was brought into legal education about the year 1870. And that's what I'm going to try to flesh out for you in this presentation. However, we won't grasp the magnitude of the changes that evolution has brought to the field of constitutional interpretation until we first have a historical perspective regarding what our founding fathers originally intended for the judicial branch of government. See, history has been so lost that we are lost ourselves in terms of thinking about what did the founding fathers have in mind when they created the judicial branch of government. So let me give us, before I describe the changes that happened about the year 1870, let me give you the way it was supposed to work. As you study the Founding Fathers, what you learn is that the Founding Fathers had a very humble role for the judicial branch of government. All they expected judges to do, and see if this is a novel idea or not, is to simply follow the intent of the authors of the text when they adjudicated controversies that came before them. In other words, they were not makers of law. They were finders of law. And all you have to do is look at a few quotes to see this. Here's Thomas Jefferson. He describes his judicial philosophy this way: "Carry ourselves back to the time when the Constitution was adopted. Recollect the spirit in the debates. And instead of trying to find what meaning might be squeezed out of the text or invented against it, conformed to the probable one in which it was passed. Okay. And here's a statement from Chief Justice John Marshall. And he was our third Chief Justice to the United States Supreme Court. And he laid out his judicial philosophy in a case in 1827. And he said, to say that the intention of the instrument must prevail, that this intention must be collected from its words, that its words are to be understood in the sense in which they are generally used by those for whom the instrument is intended, that its provisions are neither to be restricted into insignificance nor extended to objects not comprehended in them nor contemplated by its framers, is to repeat what has already been said, and more at large in all that can be necessary. And basically, you would read a quote like that, and it looks like something Charles Ryrie wrote. It's just something we all know is the literal, grammatical, historical method of interpretation. And here's a quote from Joseph Story, who at the beginning of our Republic wrote some influential commentaries on the Constitution. And this is what he says towards the beginning of his commentary. He says, the reader must not expect to find in these pages any novel views and novel constructions of the Constitution. I have not the ambition to be the author of any new plan of interpreting the theory of the Constitution, or of enlarging or narrowing its powers by ingenious subtleties and learned doubts. Upon subjects of government, it has always appeared to me that metaphysical refinements are out of place. A constitution is addressed to the common sense of the people and was never designed for trials of logical skill or visionary speculation. Now, what if the Constitution has to be changed? Certainly the Constitution was written in the 18th century, and here we are in the 21st century. Certainly there have been some changes that have happened. What happens if the document needs to be changed? Well, the Constitution itself tells you how that's supposed to happen. We have in the Constitution Article 5, which is the amendment process, which places the power to change the Constitution not in the hands of judges, but in the hands of the people's elected representatives. In fact, you need about 3/4, if I remember right, of the states to agree to a constitutional amendment. And that way, if the politicians are changing the document in a way we, the people, don't agree with, we can voice our opinion at the next election, in the next election cycle. So George Washington, I think George Washington would know something about the founding of America, wouldn't he? He says, if in the opinion of the people, the distribution or modification of the constitutional powers be at any particular wrong, let it be corrected by an amendment, the way the Constitution designates. But let there be no usurpation, though this may in one instance be the instrument of good, it is the customary weapon by which free governments are destroyed. And one of the things that's very interesting about our Constitution is that you look at it, the framers really weren't that fearful of the judicial branch of government. And here's David Barton, and he puts it this way. He says, as in many documents, the Constitution lists the most important aspects first, progressing to those of lesser consequence. Following the preamble, Article 1 describes the Congress. Article 2, the presidency. Article 3, the judiciary. Not only does the order of listing reveal their relative position of importance, but the amount of detail provided by each branch also reflects its relative importance. The legislature, Article 1, received 255 lines of print, while the presidency, Article 2, only 114 lines of print. And then the judiciary, Article 3, merited a mere 44 lines of print. So in terms of where the judicial branch of government is mentioned in the document, and in terms of how much ink is spilled talking about the judicial branch of government, we learned that the Founding Fathers were very unintimidated by the judicial branch of government. They looked at it as the least dangerous branch of government. In fact, Federalist Paper number 78. Now, if you're under 40, maybe you don't know what the Federalist Papers are because they don't teach these anymore in school. But the Federalist Papers basically were written by Hamilton, Madison, and Jay, and they were published in the newspapers in New York. And they were trying to get the New Yorkers to agree to ratify the Constitution. And so the Federalist Papers are an important source of light for us in terms of what the Founding Fathers intended. And in Federalist Paper number 78, I think it was Hamilton who wrote that, he said, the judicial branch of government is the least dangerous branch. In fact, John Jay, who was our first Chief Justice to the United States Supreme Court, refused a second nomination as Chief Justice because he thought the court could never acquire enough dignity, weight, or energy to play an integral role in the nation's affairs. So he turns down the position because he says, you know what, being Chief Justice of the United States Supreme Court is sort of a dead-end job. I think I'll pursue something that's going to have a little bit more influence. And one of the other things that's interesting is the Supreme Court didn't even have its own building until 1935. It met in the chambers many times of the legislative branch of government. And the Supreme Court didn't even meet full-time until the Eisenhower administration. And what I'm trying to show you is just what was the original vision, and now I'm going to switch to what shifted, because we really don't fully understand the shift until we understand what existed at one time. So all of these things began to change about the year 1870. Most historians and legal scholars that I've read argue that 1870 is the watershed year. And let me give you names of three people, if I could. The first is a guy named Columbus Langdell, who was the dean of Harvard Law School, and one of his successors was a guy named Roscoe Pound. And then one of their students was a guy named Oliver Wendell Holmes, who took the principles espoused by Langdell and Pound and took those principles to a 30-year career on the United States Supreme Court. And it's very important to watch this unfolding, because the shift did not start in the political arena. The shift started in academia. There was a new construct, there was a new philosophy, there was a new thought process at work. I think it was Abraham Lincoln who said the philosophy of the little red schoolroom in one generation is going to be the philosophy of government in the next generation. Just look at the 1960s generation, the campus radicals, and then look at who is running the country today, and you'll see exactly what I'm talking about. But what these three men brought in is a school of thought called legal positivism. And legal positivism, or positive law, is a new approach to constitutional interpretation. Under the legal positivist school, the goal of the judge is not to study the Founding Fathers when adjudicating controversies. Rather, it's to study society. And so what you as a judge do under the legal positivist line of thought is you immerse yourself in a changing society. And you're asking yourself, where is society moving? How have its needs, wants, and desires shifted? And then once you discover that, then you reinterpret the document to keep up with the changing society. And you say, well, that's a pretty radical change. Why was this change introduced in 1870? Well, all we have to do is go back 11 years. An influential book was published in 1859. Not a legal book, a biology book. And the name of that book was Darwin's Origin of the Species. So about 11 years had passed before Darwin's ideas began to be accepted, and legal scholars took the assumption of Darwin and began to develop a legal philosophy on this assumption. And one of the things that's very important to understand in this whole discussion is Darwinism is not just a biological issue, it is a world view. Darwinism brings with it what we would call an anthropology, or a doctrine of man. So there is a doctrine of man taught in evolutionary thinking that many of us aren't even conscious of. And so the way it works is this. If man evolved from the lower species, from the goo to the zoo to you, as the saying goes, the evolutionary process doesn't stop. See, evolution is not finished. Evolution keeps going. And consequently, man, having come from the lower species, is continuing to evolve upward. And so there is this, in Darwinism, this upward ascent of man. Now, once that's your assumption, how does that affect the world of constitutional interpretation? Well, it's very simple. We cannot be bound by an 18th century document because it's from an under-evolved era. The document is antiquated. And so the judge then took upon himself the role of guiding the evolution of society, watching where society is moving in terms of its upward ascent, and reinterpreting the document to keep up. And consequently, we all know the phrase, the Constitution became known as a living and breathing document. Now, that's an attractive phrase. I guess the opposite of that would be believing in a dead, lifeless document. But living and breathing, it's alive. And, we hear that phrase all of the time, living and breathing, living and breathing. What exactly does living and breathing mean? Well, what it means is the Constitution has a meaning independent of the original authors, is what it means. And the Constitution no longer contains a fixed set of principles, but simply evolves or changes from one generation to the next. And since the goal of the judge is to study where society is headed and to reinterpret the document to keep up, that philosophy which began to emerge resulted in a radical shift in the judge. A judge moves away from the role, his time-honored role, of studying the intent of the framers when addressing legal controversies, and instead he is no longer studying the framers, but he is studying society. He is, in essence, the person that's responsible for guiding the upward progress of the evolution of the law. And believe it or not, this is the dominant philosophy that's taught in most law schools today, this legal positivist school of thought, built on a foundation of an evolutionary assumption. Now, let me just give you a few quotes, because some of you may be thinking I'm pressing things a little too far. Maybe the connection between evolution and legal thought is not that clear. Just a few quotes on this. Here is Justice Brennan. He was on the court for a number of years. And in a 1985 address to the American Bar Association, Justice William Brennan contended that this evolutionary process, now watch how evolution keeps showing up in these statements. This evolutionary process is inevitable and is the true interpretive genius of the text. And here we have a couple of quotes from Lawrence Tribe. Lawrence Tribe is a professor of constitutional law at Harvard Law School. Lawrence Tribe, in my view, is probably the leading legal positivist today. He was probably legal positivism's number one defender. And he's a very influential man. Sometimes his words, what he says in his book, show up right there in Supreme Court opinions. And he wrote a book on constitutional law, and in the preface he says, the Constitution is an intentionally incomplete, often deliberately indeterminate structure for the participatory evolution of political ideas and governmental practices. And he goes on and he says, the highest mission of the Supreme Court, in my view, is not to conserve judicial credibility. I think they've done a good job with that, by the way. But in the Constitution's own phrase, to form a more perfect union between right and rights within that charter's necessarily evolutionary design. So what they're all arguing is that this Constitution was created to be ambiguous. And consequently, it was deliberately created ambiguous so the judge could come along and morph the direction of the language one direction or the next, depending upon the next evolutionary ascent of society. See, the judge is looking at the next quantum leap in evolution. Where is it going? And then he's reinterpreting the document to keep up. What Lawrence Tribe and others are saying is this is what the founders intended. But all we do is go back and to a few quotes I saw earlier. We saw Joseph Story's quote. We saw John Marshall's quote. To say that the intention of the instrument must prevail, that its intention must be collected from its words. We saw that quote. That's a far cry from what Tribe and others are arguing today. And so John Eidsmoe, who's really a very good person you can read on this subject. He's one of the best I've ever come across that deals well with this whole controversy. This is what he says. Underlying the disagreement over interpretation of the Constitution is a confrontation between two worldviews. Now, we all know there's a confrontation going on. We all know what happens over and over again to conservatives when they're appointed to the courts by certain presidents. They get vilified, they get dehumanized, they get attacked at every possible level. You see, we see there's a conflict. There's a conflict going on in our culture. And what John Eidsmoe is saying is underlying this conflict is a confrontation between two worldviews. The creationist, absolutist, Newtonian views of the framers versus the evolutionist, relativist, Darwinian views of most legal scholars today. And so what I've tried to show so far is, number one, what did our founding fathers intend? They intended a very impotent, almost powerless role for the judicial branch of government. And then, once evolution made its way into legal thought, they built a legal philosophy on Darwinian assumptions. And they switched, and now the judge took on this awesome responsibility of having the ability to amend the document from the bench at will to keep up with an ever-changing society. Now let me take you to the next major section of this. This really has to do with the impact that this has had on our culture. You know, you might be listening to me saying to yourself, well, Andy, that's interesting information, but does it really matter? I mean, has this really affected our lives that much? And what I would argue is that this issue I'm talking about right here has had a top to bottom alteration of American society, mostly for the worst. And I believe that this issue that I'm talking about here is the number one culture war issue facing our society today. Do you guys know that our country's in a conflict right now, right? There's a conflict raging. You would have to be comatose not to see it. There is a worldview war taking place between two lines of thought. Are we going to continue with our Judeo-Christian heritage, which has been bequeathed to us, or are we going to go in the direction of humanism? That's what's behind all of these arguments in talk shows. It's what's behind congressional hearings. It's what's behind newspaper editorials. And I believe that the issue I'm talking about here is perhaps the number one culture war issue. And so how has this issue that I'm speaking of impacted us in American society? Let me give you 4 ways. Number one, it has shifted authority in the area of constitutional interpretation from the text to the mind of the jurist. And here's Ed Meese. Ed Meese was not a perfect person, but I think he was one of the few men we ever had in public life who understood this issue well. He was Ronald Reagan's Attorney General. And this is what he says. Under the old system, the question was how to read the Constitution. Under the new approach, the question is whether to read the Constitution. So that sums it up pretty well. And let me give you a couple of quotes if I can. One is from a non-legal positivist, and the other one is from a positivist. So here is Felix Frankfurter. He's from the traditional school. He's a judge. And he says the ultimate touchstone of constitutionality is the Constitution itself. and not what we as judges have said about it. Now let's contrast that with Charles Evans Hughes, who was a legal positivist. He's a judge, and this is what he said. We are under a constitution, but the Constitution is what the judge says it is. So as you read this, you can see that there is a shift in authority from the text to the mind of the jurist. Let me ask you this. Why is it that every June, late May and June, lawyers sit around nervous, wondering what the Supreme Court's going to do? Supreme Court opinions usually get handed down in the month of May or the month of June. Everybody's nervous. Well, why are we nervous? Because if they have the power to read something into the document that's not there, I want to know, what rights did we have before that aren't there anymore? Or vice versa. And so we really, and I don't want to overstate the case, but we really in this country are not being governed by a constitution any longer. We are being governed by the latest Supreme Court opinion. And that makes sense if you're a legal positivist, because legal positivists believe that the function of a judge is not to immerse himself or herself in the views of the founders. It's to immerse himself or herself into society and its next evolutionary leap, and to reinterpret the document to keep up. There's another change that has happened, and this has to do with what we call inalienable rights. Inalienable rights are rights that are guaranteed to us because they come from God. Now, that is not the thinking of some right-wing extremist. That is the thinking of the Declaration of Independence. We are all endowed by certain inalienable rights. They are gifts from the Creator. And as legal positivism has gained ascendancy and gained greater and greater influence, what has happened is the whole concept of inalienable rights has been put under stress. If the Constitution keeps changing from one day to the next, then one day a certain right can be there, the next day it could be gone. Just ask 40 million unborn children who, prior to 1972, 1973, it was generally assumed that they had a right to be born. One day, with a stroke of a pen in 1972, 1973, that inalienable right that came from God disappeared. And the whole concept of inalienable rights stands directly in opposition to legal positivism. Because if you believe in inalienable rights, you believe in something that's fixed, something that is immutable, something that can't be taken away, because it's given from God. But if the Constitution is constantly evolving based on the latest Supreme Court opinion, then one day the right can be there, the next day the right can disappear. Here is a quote from Oliver Wendell Holmes, a legal positivist. Notice how he viewed human rights. He said, "I see no reason for attributing to man a significance different in kind from that which belongs to a baboon or a grain of sand." And here's Janet Reno. You might remember Janet Reno. She was in charge of the Clinton Justice Department, which was kind of an oxymoron if you think about it, the Clinton Justice Department. But she said, after the Waco event happened, she says, "You are part of a government that has given its people more freedom than any other government in the history of the world." Now, that is a completely inaccurate statement. She's saying rights come from government. Completely untrue. Rights do not come from government. Rights come directly from God, based on what the Declaration of Independence says. So the whole concept of inalienable rights is under tremendous stress today because of the ascendancy of legal positivism. Let me spend a few minutes talking about legal education. What has happened to legal education with the ascendancy of evolutionary law? One of the things that has happened is that the ideas of the Founding Fathers are deemed irrelevant. In fact, many would argue that the ideas of the Founding Fathers are obstacles. So John Dewey, immersed in evolution, says the belief in political fixity of the sanctity of some form of state consecrated by the efforts of our fathers and hallowed by tradition is one of the stumbling blocks. You see that? It's one of the stumbling blocks in the way of change. And Wayne Grudem, who's an evangelical theologian, puts it well. He says, if human beings are continually evolving for the better, then the wisdom of earlier generations is not likely to be considered as valuable as modern thought. And we wonder, why is it that school district after school district is moving away from Western civilization in terms of its curriculum? Why are we moving away from American history? Why is it that the generation that's coming up knows virtually nothing about our founding fathers? It's all related to an evolutionary worldview. Because if you are shackling yourself to the founding fathers, you are shackling yourself to an age that was less evolved than we are. So there's really no sense in going backwards. I mean, what really do they have to say if humanity is on this upward ascent and we are continually evolving for the better? I remember when I was a naive young law student, first year, I used to raise my hand in class, and I used to try to make arguments from the founding fathers. And I learned really fast that that's not the way you do things. In fact, one of my professors was this ACLU lawyer. She finally shot back at me one day. She said, Mr. Woods, why do you keep trying to anchor this class to the 18th century? And that's how she thought. See? And that's all a product of evolutionary thinking. If we are evolving for the better, why go back to a bygone era? Something else that has happened in legal education is the discarding of Blackstone's commentaries. If you were a law student or a lawyer sometime between the year 1760, let's say, and up until the year 1870, you were steeped in Blackstone's commentaries. In fact, Thomas Jefferson said lawyers in his day read Blackstone's commentaries the way Muslims read the Quran. And here's a quote from a judge in 1799. He says, for nearly 30 years, Blackstone's commentaries has been the manual of almost every law student in the United States. And its uncommon excellence has also introduced it into the libraries and often to the favorite reading of private gentlemen. I'm embarrassed to say that I went all the way through an education in political science and all the way through a legal education. I had become a member of the California State Bar, and I didn't have the foggiest ideas what Blackstone's commentaries were. Yet, these were the premier commentaries that were used in legal education. And what was special about Blackstone's commentaries is that they based law on what the Creator had revealed. God, Blackstone said, has revealed certain principles. He's revealed that in creation, natural revelation, and he has revealed it in Scripture, special revelation. And Blackstone specifically said that the function of a law is to operate within those fixed principles. In other words, the function of a lawyer, the function of a judge was to discover these fixed principles that the Creator had established and then to fashion ordinances or laws that operate within the framework that God had established. So here's a quote from Blackstone's commentaries. He says, thus, when the Supreme Being formed the universe and created matter out of nothing, he imposed certain principles upon that matter from which it can never depart, and without which it would cease to be. If we farther advance, from mere inactive matter to vegetable and animal life, we shall find them still governed by laws, more numerous indeed, but equally fixed and invariable. Man, considered as a creature, must necessarily be subject to the laws of his Creator, for he is entirely a dependent being. Now look at this last sentence here. No human laws should be suffered to contradict the laws of nature and the law of revelation. So what he is saying is discover those fixed principles and fashion human law accordingly. But as legal positivism gained ascendancy, what began to be discarded? Blackstone's commentaries. Well, why would you get rid of Blackstone's commentaries? Because legal positivism is going in the exact opposite direction. Legal positivism is saying everything is changing. Everything is in a state of flux. There is nothing that is fixed. And anything that is considered fixed or immutable, you begin to discard. Blackstone's commentaries begin to disappear to the point where Blackstone's commentaries are a relic collecting dust in a library somewhere, when these, in fact, in the pre-Darwinian era, were the dominant commentaries. Inalienable rights begins to disappear as well. And something else began to happen in legal education, and this is what we call the introduction of the case law method. And the case law method of schooling basically is the idea that you spend more time studying what judges have said about the Constitution than you do studying the Constitution itself. See, this would be the equivalent of going to seminary, for example, and spending all your time studying theologians, but you don't spend any time in the actual text. And so here's a quote from Pat Robertson. This is not an endorsement, by the way, of everything Pat Robertson has said and done over the years, but I thought this quote was interesting. The man does have a degree from Yale Law School. His father was a United States Senator, and he says this in one of his books. I spent 3 years getting my law degree at Yale Law School. From the moment I enrolled, I was assigned huge leather-bound editions of legal cases to study and discuss. I read what lawyers and judges, professors, historians said about the Constitution, but never once was I assigned the task of reading the Constitution itself. Now, that's been my experience as well. Well, the Constitution, just read that on your own. Let's get to these cases. Now, that's the outworking of a legal positivist paradigm. Because if the judge can evolve the document upward, the important thing is not the document, is it? The important thing is the latest Supreme Court opinion. So as a result, this is shocking to many people, but most lawyers know almost nothing about the Constitution. It's not an assignment. It's not required reading. Most bar exams, as you take the bar exam, they seldom test on the actual text of the Constitution. All of the questions basically deal with what various courts have decided about the Constitution. And this has all expedited by what we call postmodern Reconstructionism, or not Reconstructionism, deconstructionism, which is the idea that the intent of the author is unknowable. Justice Brennan, it is arrogant. Now that's an important word, because what he is saying is if you think you can get back to the intent of the author, you are arrogant. It is arrogant to pretend that from our vantage point, we can gauge accurately the intent of the framers on application of principle to specific contemporary questions. All too often, sources of potential enlightenment, such as records of the ratification debates, provide sparse or ambiguous evidence of the original intention. And apart from the problematic nature of the sources, our distance of 2 centuries cannot but work as a prism refracting all we perceive. And what he is saying is 2 things. Number one, we don't really know what the founders thought because they never really wrote enough to tell us. And the things that they did write don't relate to the things that we're experiencing today. And I have in your paper that I have on your disc a quote from Robert Bork in one of his books, and he completely debunks that. He shows that the founders were voluminous writers. We have the ratification debates. We have the Federalist Papers. We have the Anti-Federalist Papers. We have the commentaries that the founders wrote on the text of the Constitution. And the second thing that Brennan is saying is even if we could understand what the founders were saying, we are 21st century people trying to read the minds of 18th century people. We're 21st century people trying to study an 18th century document, and so we're all coming to the text with our 21st century presuppositions. Therefore, I can't really read what the founders said because I'm reading my own 21st century biases backwards. And this is postmodern deconstructionism. Now, if he's right on this, I don't know what hope we have as Bible believers, because here we are going all the way back to the time of Moses. in 1446, when the Exodus happened and when the Pentateuch was probably written, he's writing in a totally different language, a totally different culture. We do the same thing in the New Testament with Greek. And are you telling me, Justice Brennan, that we can't go back 200 years in our own culture, in our own language? See, he's just cut out the legs from biblical interpretation with that particular statement. One other area that this legal positivism has brought tremendous changes is in the area of democracy. This whole issue has challenged the notion of democracy because what it has done is it has placed the power to amend the Constitution at will in the hands of 9 life-tenured, unelected people. Remember, these federal judges are appointed for life. And if I don't really like the decisions they've made, what recourse do I have? I really have none, because they're appointed for life. Now, I said 9 life-tenured appointed judges, but really it's 5, because the only thing you need for a majority opinion is 5 votes. In fact, there was a famous quip that was used by legal positivists in the Warren era. And they said, with 5 votes, we can do anything. And that's true. And what has happened is even democracy itself has been challenged. And here's John Eidsmoe. He says that the Constitution is more than the written document signed in 1787, rather than the various decisions of the Supreme Court are part of the Constitution, and these, along with the document, are the true constitution of the land. It has even been said that the Supreme Court sitting in session is a continuous constitutional convention. So what, in essence, they're doing is they're placing their own latest ruling on equal par with the document itself. And in the paper, I quoted a judge, Judge Hamilton, I think his name was, a recent appointee. And he basically said in his hearings that his writings are, in essence, footnotes to the Constitution. Why would he say that? Because he thinks he's got the power to evolve the document in an upward direction. And so, in essence, what has happened is we are being governed by an oligarchy. You recognize oligos from your Greek studies. Oligos means small or few. And so an oligarchy, in essence, is being governed by a few small number of life-tenured, unelected people. And that is the ripened fruit of legal positivism. Thomas Jefferson warned about this. He said, "You seem to consider judges the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men and not more so, and their power the more dangerous as they are in office for life and not responsible as the other functionaries are to elective control. The Constitution has erected no such single tribunal." Here's a quote from, sorry about the small font, Lino Greglia, who is within the profession. He was actually appointed by Reagan to the federal court, and he did not get confirmed because he was considered not politically correct enough. But he is a law professor, and this is what he says. "Judicial usurpation of legislative power has become common and so complete that the Supreme Court has become our most powerful and important instrument of government in terms of determining the nature and power of American life. Questions literally of life and death, of public morality, and of public safety are now in the hands of judges under the guise of constitutional law. The fact that the Constitution says nothing of abortion has made no real difference. The result is that the central truth of constitutional law today is that it has nothing, this is an important point, it has nothing to do with the Constitution. What he's saying is constitutional law has nothing to do with the Constitution, except that the words due process or equal protection are almost always used by judges in stating their conclusions. Constitutional law has become a fraud, a cover for a system of government by the majority vote of a 9-person committee of lawyers, unelected and holding office for life. And people say this legal positive issue, this evolutionary issue, just doesn't impact daily life. You can see there's been an alteration of our society because of this issue. Just a couple of illustrations of this, and I'm getting ready to wrap up here in just a minute. Do we have any illustrations of it? Let me just give you a few. In a concurring opinion in a 1972 case called Furman versus Georgia, William Brennan argued that capital punishment, as it was then practiced in the United States, was unconstitutional. Now, that's a hard argument to make because the Fifth Amendment specifically says that the state can take life if due process is afforded. See, Brennan's opinion on capital punishment was contradicted by the text of the Constitution. And in fact, capital punishment was regularly practiced in colonial America, in the founding of America. But Brennan made a decision that today capital punishment is unconstitutional. He made a decision that it was time to evolve the document upward. And so he developed this phrase, evolving, there's our magic word, evolving standard of decency. And this case was eventually overruled, but the Supreme Court was this close to illegalizing or outlawing capital punishment throughout the country because of the evolutionary progress of the law. Of course, the ultimate example of this is Roe versus Wade. You can read the Constitution all you want. You're not going to see the words abortion in the Constitution. In fact, where did they get this idea that someone has a constitutional right to an abortion? They said it's in the penumbras. Now, I was a young law student. I said, what in the world is a penumbra? I had to go look the word up. A penumbra is a shadow. That's what it is. If the shadow casts a particular direction, veiled in the shadow somewhere is going to be this constitutional right to have an abortion. And they said it's time to evolve the document upward. Our society is enlightened, and we are now evolved to the point where we have to embrace what they call reproductive freedom. That's not my name for it, by the way. I would call it baby killing. They would call it reproductive freedom. And so the Constitution has evolved, society has evolved, and so now we're going to evolve the document to keep up. See, Roe versus Wade is classic legal positivism. And then there were the separation of church and state cases in 1962 and 1963. You know, my mother, when she talks to me, she's describing a world that I had no idea even existed. It was a world in which her own elementary school teacher would read from her Psalm 23. And I said, did that really happen? She says, yes, that really happened. But see, something shifted in 1962 and 1963. Today, that would be almost a federal lawsuit to do something like that. Well, the judges decided it's time to evolve the document upward. After all, we are a multicultural society. We can't just have the Christian view being taught in the public schools, so we have to eradicate Christianity from the schools. And they developed a phrase that they used for this called the separation of church and state. They called it a strict wall between separation of church and state. There's just one little problem with that. Go read the First Amendment. You're not going to find the word strict. You're not going to find the word wall. You're not going to find the word separation. You're not going to find the word church. And you're not going to find the word state. Other than that, I guess you're fairly close. See, it was time to evolve the document upward. And so they read something into the text that wasn't there. And the American's landscape has changed. In fact, they made that decision without citing a single precedent. A precedent relates to how a similar court in the past with a similar set of facts handled that case. Precedent is really the linchpin of the American legal system. Lawyers go into courtrooms making arguments based on precedent. And yet this is what the court said 1 year later. Finally, in Engle v. Vitale, only last year, these principles were so universally recognized that the court, without the citation of a single case, see that? Reaffirmed them. And so Justice Scalia, who's one of the few positivists on the Supreme Court today, looks at this, and this is what he said in one of his cases. What secret knowledge, one must wonder, is breathed into lawyers when they become members of this court, that enables them to discern that a practice which the text of the Constitution does not clearly proscribe, and by which our people have regarded as constitutional for 200 years, is in fact unconstitutional. Day by day, case by case, this court is busy designing a constitution for a country I do not recognize. See, this is all the ripened fruit of evolutionary law. Very quickly, as I'm getting ready to close here, I know I said that 10 minutes ago, but this time I really mean it, right? Where is this whole thing going? Where is it going? If the function of a judge is to immerse himself in the evolutionary progress of society and to reinterpret the Constitution to keep up with the evolutionary progress of society, if that's our paradigm that we're working from, my question is, where's the next evolutionary leap? See? In other words, if they already used evolutionary law to come very close to illegalizing capital punishment, if they used evolutionary law to usher in abortion on demand, if they used evolutionary law to sweep our Judeo-Christian influence out of the public schools, my question is, what's the next thing they're going to do? And one of the things that's interesting to me as I study social Darwinism and social evolution is that the pinnacle of evolutionary thinking is globalism. What is the zenith? What is the height? What is the apex of social Darwinism? The height of the whole thing is globalism. In other words, once man arrives at a global world government, he will achieve the high point of evolutionary thinking. That's as high as he can go, other than becoming a god, I guess, on the evolutionary spectrum. And that's where everything is moving. And so here's a couple of New Agers. They say, despite all of the contemporary stresses and strife, an objective analysis of the historical record will show that humankind is experiencing a continuous, though wobbly, movement to a more cooperative world order. And a few pages later, they go on. We have seen that humankind is not simply moving in a vicious killing circle. It is on an upward climb toward completing the governmental structure of the world. We are inspired by our great progress toward planethood. In other words, the evolutionary process hasn't stopped. That's what I've been arguing this whole time. It continues even to this day, and it's continuing to evolve upward into globalism. And this type of thinking is everywhere. I was even on a ride not too long ago at Disneyland. And it was this particular ride where you start at the bottom and the tram sort of cycles upward. And it starts off with atoms and molecules, and you keep moving up, and then suddenly, an ape appears, and then man appears. You're cycling upwards. Man is killing his fellow man, and he doesn't have language yet. He doesn't know what fire is yet. But suddenly he becomes more sophisticated. He becomes more intellectual. The evolutionary process is going, and you keep cycling up. Wars start to stop. And you get to the top, and you get out of the ride, and there's a sign that says, "Welcome to the global village, our new global village." And that is, in essence, social Darwinism. Man will have achieved the height of evolution once he arrives at globalism. And so since the court is following an evolutionary trajectory, which is what I'm trying to argue in this presentation, then it stands to reason that we should see globalism show up in Supreme Court opinions. In fact, that is exactly what we see. Let me give you two quick cases. The first is called Bowers versus Hardwick, 1986. This dealt with an anti-sodomy statute. There was a statute in the state of Georgia which made it illegal to commit sodomy. And of course, the gay rights activists were very upset about that statute, that law, and so they brought it to the attention of the Supreme Court. This case made it all the way to the Supreme Court, and the Supreme Court looked at the statute, they looked at the Constitution, and they said, you know what, we don't even agree with this law, but there's nothing in the Constitution that would make it illegal. In fact, the court pointed out that there were many similar statutes on the books at the time the Constitution was adopted, debated, and ratified. Now, fast forward now from the year 1986 and go with me to the year 2003. Which is there's really not that long of a period of time, is there, between 1986 and 2003. And now, in a case called Lawrence v. Texas, the exact same facts, this time from the state of Texas, come before the United States Supreme Court. Dealt with an anti-sodomy statute. And this time, the court struck the law down. They said it's unconstitutional. Now, the question is, what was the difference between 1986 and 2003? Why in 1986 the law's okay, 2003 the law's not okay? Well, the answer to that is now the court is looking at a different source of authority. See, the 1986 court was looking at our own heritage and our own Constitution. This time, the minds of the judges was not on our own heritage and our Constitution. Rather, it was on world opinion. What does the world think about this? They quoted in that case the European Court of Human Rights, for example. And what you find as you take those two cases and you compare them is there's a very clear trend in our legal system away from our Constitution and heritage into foreign sources of law. And your average American looks at this and scratches their head. This seems absolutely insane. I thought our leaders took an oath to our own Constitution rather than world opinion. And by the way, if world opinion is going to be our guide, you better grab your guns quick, because I don't know if the Second Amendment is necessarily respected around the world. I don't know if freedom of religion that we enjoy meeting in this room is respected around the world. But if you are trapped in a legal positivist mindset, tracing the evolutionary development of society, the decision makes perfect sense, because the height or the zenith of social Darwinism is globalism, and if that's true, we should see globalism show up in Supreme Court opinions. And the fact of the matter is that is exactly what we are seeing. So in conclusion, back to where I started, we're dealing with this subject of evolution and creation, and we have to understand that we are not simply dealing with a scientific or biological issue, as important as that is. This has worldview ramifications. Legal philosophers beginning in 1870 took Darwinian assumptions and they built on those assumptions a framework or a philosophy for constitutional interpretation. And so the very things that we are seeing happening all around us are simply the ripened fruit of that new legal philosophy. And all of that to say, and this is why I'm going back to Henry Morris. Henry Morris is one of the first to point this out, that evolution is the seedbed of all of the various isms and anti-God philosophies of our day. I've just tried to expound a little bit more on how it has affected evolution and our legal system. So all of that to say, we're here in this room in the year 2010. We're hearing about dinosaurs. We're hearing about the age of the earth. And I want us all to understand that the discussion that we're having here on this subject is instrumental, because it far transcends biology. It far transcends the normal scientific debate that we hear about. It has impacted philosophies of government and even our own philosophy of law in our own United States of America. And it has resulted in a top-to-down realteration of our society.